All right. I'd like to call to order this meeting of the Currituck County Board of Adjustment for July 14th, 2022. Could I have the clerk please call the roll?
Absolutely. Roy Breathwaite,
Present.
Stephen Braddock,
Present.
Carol Bell, Kathy Bonetone,
Present.
Robin Kane,
Here.
Sam Miller.
Present.
All right, it looks like we have a quorum tonight with 4 regular members and 1 alternate member. Mr. Robin Kane will serve as alternate for Ms. Bell tonight. Approval of the agenda. Do we have any changes to the agenda for tonight? I understand that there is one.
Well, Mr. Chair, item A under old business, I received correspondence from the attorney representing Frog Island. They've requested that this be postponed till September. The county had no objection. They're trying to work some other things out. It may not even need to come before the board, so we went ahead and agreed to have that set off till September.
Right. Okay.
And we told them they didn't need to appear for
Right.
that tonight. So
Okay.
that can be removed. It'll just be put on in September.
Okay, good. Thank you. Any other changes to the agenda? So do I have a motion to approve the agenda as presented or amended?
I'll make a motion to approve the agenda, removing old business item A.
A second.
All right. All in favor, say aye.
Aye.
All in favor, say nay. Motion carries. All right. Approval of minutes for the June 16th, 2022 hearing. Are there any changes proposed for the minutes?
Mr. Chairman, I was going to mention that I had noticed when these had gotten sent out that there were a few spelling errors, and I notified Cherie of that, and I believe this is the corrected version.
Okay. All right. Any other proposed changes to the minutes?
No.
All right. Do I have a motion to approve the minutes?
Make a motion to approve the minutes.
Is there a second?
Second.
All right. All in favor, say aye.
Aye.
All opposed, say nay. Motion carries. All right. If there's anyone in the audience that wishes to speak tonight, we don't have much of an audience here tonight, but please sign in, and if you have not already done so, I'm going to move to disqualifications now. In accordance with the State Government Ethics Act, it is the duty of every board member to avoid conflicts of interest. Does any board member have any known conflict of interest with respect to any matters coming before the board tonight?
No, I do not.
Okay. All right. So we'll move to the swearing in. All participants for the case tonight, including the staff, could you please step forward and be sworn in? All right. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. As a reminder, tonight's case is an appeal, which requires a simple majority of this board to make a determination. And we'll go right into the cases. So old business, as we said, Frog Island has been carried to September. New business, BOA 22-03, Edward Delaney and Tara Murphy. Request for an appeal of the letter of determination from Currituck County dated May 12th, 2022, which concluded tax map 101C, parcel E, Seagull Subdivision, Fruitville Beach Township is not a lot of record on which development may occur. All right, and at this time, I'd like to ask the county to present its case.
Yes, Mr. Chairman, the county calls Kevin Kemp.
All right, Mr. Kemp?
Could you please state your name and how you're employed?
Kevin Kemp, I'm the Development Service Director for Currituck County.
And Mr. Kemp, what is your educational background?
I have a bachelor's in industrial design from James Madison University and a master's of architecture from University of Michigan.
Okay, and prior to your employment with Currituck County, what has been your employment experience?
For 10 years prior to Currituck County, I worked with the City of Virginia Beach as a zoning inspector, planner, and then for 5 years as the zoning administrator.
And what were your duties and responsibilities in those positions?
To interpret and enforce the zoning ordinance, manage the zoning staff. As a planner, I took items before the Planning Commission and City Council for approval.
And in your current role as the Director of Currituck County Development Services Department, what are your duties and responsibilities?
I manage both the Permits and Inspections Division and the Planning Division. I enforce and interpret the UDO, review plans for compliance with all regulations, and act as the zoning administrator for the county.
In the course of your employment, you're familiar with the matter before the board tonight?
Yes, sir.
And how are you familiar with that matter?
My staff and I did research on this lot based on a request from the applicant.
Well, let me ask you, first of all, this matter involves a parcel of land in Seagull Subdivision, is that correct?
Yes, that is correct.
Okay. And is that the parcel that's shown on the screen?
Yes, sir.
Okay. And at some point, did you receive a request for a letter of determination or interpretation regarding the status of this particular parcel of land?
Yes, sir.
Okay, what was the nature of that request?
It was a request as to the buildability of the lot, whether it could be developed.
Okay. Whether, in fact, it was an existing lot of record such that it could be issued a building permit, is that correct?
Yes, sir.
Okay. And upon receipt of that request, what did you do?
Staff and I found the old files for the subdivision. We reviewed them, reviewed all the documents in them, and I composed a letter back to the applicant with my determination.
Okay, well, let's kind of walk through that letter. I guess, first of all, how do you make a determination under the Unified Development Ordinance whether a lot or parcel is deemed to be an existing lot of record?
Well, we look at the lot, we look at the when it was created, the plats and/or deeds associated with it. Then we look at the ordinances at the time it was created to see if it meets all the dimensional requirements of the time.
Okay, does the Unified Development Ordinance provide a definition or language for you to apply when making such a determination? Somebody else may have to press this button, Tammy.
Is it?
She would take it to the definition.
Tammy, is it turned on the side?
Maybe it has to be turned off.
Oh, there it is.
Yeah, it should work now.
Okay. Turn it on, that's the magic. Okay, you see on the screen, is that the definition from the Unified Development Ordinance of existing lot or lot of record?
Yes, sir, in Chapter 10.
And is that the language in the Unified Development Ordinance that you then apply to making a determination as to whether a lot is deemed a lot of record?
Yes, sir.
Okay, if you then please if you'd walk through your analysis and what determination you made as you applied this particular section of Unified Development Ordinance.
Okay, well, first we looked at whether it's part of an approved subdivision, which it is. It was part of the Seagull subdivision. This subdivision was approved by the Board of Commissioners June 28th in 1974, June 17th in 1974, and then recorded June 28th. A slight revision in September was considered, just shifted some right-of-way lines. So ultimately, the plat was recorded September 4th, 1974. Included on that plat were 33 buildable lots, numbered 1 through 33, and it also included 6 lots lettered A through F. Looked at the lot, specifically Lot E, and as to whether it met the zoning requirements in 1971 subdivision regulations, which are 20,000 square feet, 100-foot width, and 200-foot depth. The lot did meet the square feet and width requirements. However, it did not meet the 200-foot minimum lot depth. Therefore, it did not meet the criteria and was not a lot of record. So that was the first. The secondly, we went and looked at the lot of record, whether it was described by meets and bounds and recorded, and it was not recorded, described by meets and bounds, and it, again, did not meet the regulations of the time. Third, whether it was recorded in the office register of deeds created prior to August 2nd, 1965, which it was not, as it wasn't meeting the dimensional requirements. Fourthly, a lot upon which an existing structure is located, provided a valid building permit was obtained. This lot is vacant, so there was no building permit on it. And then lastly, as I mentioned, we looked at, as we did several times, as to whether it met the dimensional requirements of the time, which it failed to meet the depth requirement. And so based on that, we determined it was not a lot of record.
Okay, I ask you to focus in on what is included in the agenda package as attachment D and shown on the screen. What is that document?
This is the preliminary plat for the subdivision.
Okay, and what was the date of that plat?
The date of that plat, hold on. It is very small. Let me look in there.
Looks like is that June 6th, 1974?
Yes, that is correct.
Okay, and you reviewed this plat in making your determination?
Yes, sir.
And what information did you derive from this preliminary plat for Seagull subdivision?
We looked at a couple things. One, that the plat was in conformance with the final plat. But more importantly, we looked at that table, which is circled there on the slide. And this broke out the acreage for the subdivision. It had the total acreage of 28.003 acres with 33 lots. But most importantly, it labeled the acreage in parks and other uses as 4.879. When you add what became parcels A, C, D, E, and F, that came out to exactly 8.79 acres. So because of that, we deduced that that Lot E was included in that other use category.
And so what is the significance of a preliminary plat?
Preliminary plat, the significance is that when you go to record a final plat, it has to be in conformance with the preliminary plat.
All right. Now I'll show you what's on the screen, and also included as attachment C in the board agenda package. And what is that document?
That is the final recorded plat, map book 5, page 50, that was recorded September 1974.
Okay, and upon your, and you reviewed that plat in making your determination?
Yes, sir.
And did you determine that that plat was in conformance with the preliminary plat that you also had reviewed?
Yes, sir.
And in fact, would it have, I think as you testified, it would have to have been in conformance in order for it to be approved and recorded, is that correct?
Yes, sir.
Okay. And so then you would expect, or did you find then that there were the same number of lots and the same number of additional area as you had calculated from the preliminary plat exhibited on this final plat?
Yes, sir. There were the same amount of lots, and the other land that was labeled other usage was essentially the same.
Now, let's look more closely at the requirements for a lot or subdivision regulations. And at the time that Seagull subdivision was approved, if you please walk the board through the requirements for a subdivision in 1974.
On 1974, a lot would have had to meet the subdivision regulations from 1971 because this lot was located in an area without county water or sewer. It would refer to Section 3A2, and that says, in areas lacking both community water and community sewer systems, the minimum lot shall have 20,000 square feet of usable land, not less than 100 feet width at the building line, nor less than 200 feet depth.
Okay, and so you've testified that the issue with regard to this lot or parcel of land is the lack of 200-foot depth
Yes, sir.
in the lot width. Is that correct?
Yes, sir.
Okay, and how did you determine that this lot did not meet the required lot depth?
We looked at the lot, determined what the front of the lot was, and then we looked at the definition of lot depth in the 1971 zoning ordinance and applied that to the lot and found it to be shorter than 200 feet.
Let me approach the witness. I'll show you what has been marked, will be marked as Exhibit G, County Exhibit G for purposes of identification, to ask if you recognize that document.
Yes, sir. This is the 1971 zoning ordinance. A few pages from the definition section.
Okay, and is that a true and accurate copy of the 1971 zoning ordinance maintained by your department?
Yes, sir.
Okay. And so you testified that you reviewed the definition for lot depth, is that correct, in determining whether this particular parcel, Lot E, met the depth requirements?
Yes, sir.
All right, and what is lot depth, how is lot depth defined?
Lot depth is the depth of a lot is the mean distance of the sidelines of the lot measured from the midpoint of the front lot line to the midpoint of the rear lot line.
Okay, and so the plat showed what was the sideline distance for Lot E is shown on the final plat?
The side distance at its largest point, which was the northernmost point, was 167.07 feet.
But actually, in determining the lot depth and applying this definition, would it be somewhat less than that?
Yes, given the shape of the lot, by the 1971 definition, you would take the calculation from halfway from the front lot line, which is the eastern lot line that fronts the right-of-way, so it would be less.
So in any event, in 1971, the lot would not have met the 200-foot required depth.
That is correct.
All right. And would the lot today, under today's definition and calculation, meet the lot depth requirement? In fact, if I may approach the witness.
Certainly.
I'll show you what will mark as the County Exhibit H. For purposes of identification, ask if you recognize that document.
Yes, sir.
And what is that?
This is a copy from the current Unified Development Ordinance.
Is that a true and accurate copy of the current Currituck County Unified Development Ordinance maintained by your department?
Yes, sir.
Okay. And what is the significance in that document relative to the measurement of depth of lots?
The significance is, looking from today's standards, the lot depth is the horizontal distance between the front lot line and the rear lot line. It also defines what the front lot line is, in that it is at the edge of the street. So even given today's current ordinance standards, it wouldn't meet the lot depth.
You noted that as F?
Yes.
Section F? Okay.
Well, which one is that?
That's the one you just passed up. E was the,
Well, I'm going, well, the agenda package has A through E,
A through D.
or A through D, okay, then let's
Okay.
change the,
I just want to make, I have, the last thing I have in the agenda packet is attachment D,
okay,
and then we get, this would be E,
yes,
okay, and then this would be F.
yes,
Okay.
thank you. So having then gone through your analysis of the relevant plats and ordinance provisions, what was your ultimate determination with regard to the status of Lot E as shown on the Seagull subdivision plat?
I determined that the lot was not a legal lot of record and therefore could not be built upon.
Now, the applicant notes that there are two other similar parcels that are shown on the Seagull subdivision plat that have apparently been deemed at some time since 1974 buildable. Is that your understanding?
Yes, sir. Two of the lettered lots have been developed with single-family homes.
In particular, I think Lot A is one cited by the applicant in their application. Can you explain to the board how that lot became was deemed buildable sometime after 1974?
Yes, sir. For this lot, the applicant or the person who wished to develop the lot inquired with the planning department. The chief planner at the time, H.B. Briggs, wrote the personal letter in December of '94, and what the letter said is that it wasn't a buildable lot for this lot. It was because it did not have the appropriate access. So in that letter, the chief planner said that if you can provide at least a minimum of a 20-foot access way to either Sam Piper or Sam Fiddler Road, then it could be recorded. So on July 24th, 1995, an amended final plat was recorded, and that put a 20-foot access between lots 32 and 33, which made that lot, provided it access and made it buildable. At the time, the zoning regulations required a lot be 30,000 square feet. The lot that existed was 69,107, so it met the other applicable zoning requirements. And they pulled a permit and built the home.
And from your review of the the ordinance in effect in 1974, did that parcel labeled Parcel A meet the other minimum requirements for a subdivision or a lot created in 1974?
Yes, sir.
Okay. Met the depth?
It met the depth, the square foot, and the width.
And so it was just lacking the access, and that was cured in 1995, is that correct?
Yes, sir. The letter from the chief planner identified that there were 3 reasons why a lettered lot may not be developable. One was dimensional standards, one was that it had unsuitable soils for development, and the third was access. In this case, it was the access that was lacking.
Okay, now, do you also look at the history of parcel D that appears on the Seagull subdivision plat?
Yes, sir.
And again, that is another parcel that the applicant notes has at some point been deemed to be developable or eligible to receive a building permit. What did your review of that lot lead you to conclude with regard to how it became a buildable lot?
Well, on February 3rd, 2000, a recombination plat was recorded for Lot 33 and Lot D. What this did, when there was a 20-foot access way for Lot A, there was a small residual parcel, a little 4,000 square foot wedge was created. What this plat did was it combined that wedge into Lot 33, but what it also did is it shifted just slightly the lot line for Lot D over. It increased the lot area by 132 square feet, which made it 2,010 square feet.
Would be 20,000?
20,010 square feet. So it was over that threshold. A building permit was issued December 31st, 2003. We pulled the building permit, and the building permit, the planner at the time marked the lot a lot of record, and a building permit was issued.
Does parcel D meet the minimal requirements, minimum requirements that would have been required in 1974?
Yes, sir.
So from your review, what was it that made, was it the addition of square footage that made parcel D a buildable lot?
Yes, sir.
All right, I don't have any further questions at this time, Mr. Chairman.
Okay. I'd like to give you an opportunity to redirect, if you like.
Thank you, Mr. Chairman. First, for the record, my name is Kraus Gray. I'm an attorney in Killable Hills, North Carolina, and I represent the applicants in this matter. They had other things that they were unable to attend, and they wanted to let you know that it wasn't not due to anything, but from Florida to here was going to be a problem for them. If I might ask you a couple of questions, sir.
Yeah, absolutely.
One, as I understand it, you've been here in this county for the job you presently have for approximately a year, correct?
Yes, sir, 1 year.
All right. Now, when you reviewed, well, let me do this. May I approach?
Yes.
Sir?
Just as Mr. McCree has done, I've tried to pull out what I think are
Do
some
we have one
pertinent-
more, or is that the only?
Pardon?
Do we have one more copy?
Yes.
We need 2 more if you have them.
I only got one more.
That's fine. I will use it, and then I will share with the clerk. It's fine.
Well, I'll take ice away.
That's fine. Not to worry.
I've already seen it all.
Thank you.
First, I want to focus a little bit. You have obviously a fair amount of experience dealing with subdivisions. Is that correct?
Yes, sir.
All right. Now, when a developer or someone submits a preliminary plat, it first goes to staff. Is that correct?
Staff reviews the plat, yes.
And occasionally, staff recommends modifications, changes, or other things to the developer, or may suggest that there are things within that plat that don't meet the ordinance. Is that correct?
Yes, sir.
And typically then, a preliminary plat then comes back showing whatever changes the developer agreed to make.
Yes, sir.
And is that rare, or is it normal?
Well, in my experience, it goes through our TRC. Usually there are some comments. So yes, I'd say most plats that go through TRC, it takes a couple submittals.
For purposes of the record, what's TRC?
Oh, sorry, Technical Review Committee. It's the members of staff that review development applications.
Yes, sir. And after it goes to the TRC, it then ends up going, at some point in time, typically going to the planning board, correct?
Correct.
And I believe you've reviewed the zoning ordinance, the subdivision ordinance from 1971, correct?
Correct.
And that had procedures where it would go to the planning board, correct?
Correct.
And when it went to the planning board could also recommend modifications or changes to plats, correct?
Correct.
Now, I submitted to you a request for information,
Yes,
correct?
sir. Yes, sir.
And you did in fact provide a whole pile of stuff to me,
Yes, sir.
correct, sir?
Yes, sir.
All right, and within that was copies of the various ordinances, and also that preliminary plat that you showed up here earlier,
Yes,
correct?
sir. Yes, sir.
All right. I didn't get any notes from the planning board from 1974. I'm assuming there are none.
We were not able to find any. There were none in our folder, in
All
our
right.
file.
And we had an original subdivision plat that was approved by the commissioners, correct?
Correct.
And then later in September, a further plat was approved by the commissioners.
Correct.
When the commissioners approved the plat, was there anything in the commissioners' minutes that showed they had any discussion regarding the plat that was submitted to them?
No, sir.
All right. And as far as you know, the plat that is recorded, which was signed off on by the commissioners, is in fact the plat that they reviewed,
Yes, sir.
both in the preliminary one, not preliminary, excuse me, the first one that was recorded, as well as the second one that was recorded.
Yes, sir.
All right, sir. Now, in my packet that I've submitted is a copy under tab 1 of my initial request that was sent to Mr. McCree, which he then forwarded to you for a response, where I'd asked for an official opinion. Is that correct, sir?
I don't have your
You don't
binder
have
in
that.
front, but yes, sir.
All right. And I'd asked in particular, as such, please accept this letter as a formal request for a written determination by Currituck County Attorney regarding the status of Lot E as to whether it is an approved lot pursuant to the original subdivision plats referenced above or not, and if not, please articulate the underlying basis for that determination. Is that correct?
Correct.
All right. Can I ask you to turn to tab 2, which is your official response back to me? Do you see that, sir?
Yes, sir.
And is that, in fact, the official response to my communication?
Yes, sir.
All right. Now, in your second paragraph, it says the approved plat includes 33 buildable lots and 6 non-buildable lots, in quotation marks, A through F, in quotation marks. Lots A through F were not and could not have been recorded as buildable lots for one or more of the following reasons. lettered lots did not meet dimensional requirements of the subdivision at the time, in paren 20,000 square feet minimum lot size, 100-foot minimum lot width at the building line, and 200-foot minimum depth, correct?
Correct.
Number 2, the soils were not suitable for on-site wastewater system. Or 3, the lots did not have adequate access. Correct? Now, is there anywhere within that letter that you specifically stated that Lot E did not comply because of the 200-foot minimum depth?
No, sir, I don't see that.
All right, sir. Now, if you'll turn, if you would, for me, please, and I do apologize that I didn't have a booklet for you, to tab number 3, which is a copy of the subdivision plat as recorded in Map Book 5, pages 33 and 35. Does that look familiar to you, sir?
Yes, sir.
And you did, in fact, review that survey at the time that you wrote your letter to me.
Yes, sir.
All right, now, I want you to look, if you would, for me, please, at lot 16 on that subdivision plat.
Okay.
All right. Tell me what's the front of lot 16?
I would need to read the, refer to the definition and how a corner lot is measured.
Well, it's in your exhibit that you provided. If you look, it's 61.18, and on Exhibit E, I believe it is.
Okay, corner lot. A lot which occupies the interior angle at an intersection of two street lines which make an angle of more than 45 degrees and less than 135 degrees with each other. The street line forming the least frontage shall be deemed the front of the lot except where two street lines are equal, in which case the owner shall be required to specify which is the front when requesting a zoning compliance permit.
All right. Having read that definition, going back to my question to you, sir, if you look at lot 16, would you please tell me which of those lot lines is the front? The north or the east?
The eastern lot line.
All right. Then looking at the north lot line, what's its distance?
170.71 feet.
Is that 200 feet, sir?
No, sir.
All right, I want you to look at the south line of lot 16. What is that distance?
The middle letter's difficult to read, but I believe it's 167.91.
Well, in any case, it's less than 200 feet.
Yes, sir.
Is that correct?
Yes, sir.
All right. Would you look at lot 17, please?
Okay.
Would you look at the east and tell me which of the lot lines is in fact the front lot line on lot 17?
The eastern property line.
All right. Then looking at the southern property line, approximately, because I know it's very difficult to read even with my glasses on, what is that distance?
It appears to be 167.65.
All right. Would you please look at the north property line of lot 17? What is that distance?
159.99.
And I think we've established all of those are less than 200 feet. Is that correct?
Yes, sir.
But this plat was approved.
Yes, sir.
All right. I want you to look at parcel E that you have looked at now numerous times. Where's the front of that lot?
Eastern property line.
Well, isn't the shortest distance on the southern property line?
This was not considered a corner lot
Why not, sir?
because the right-of-way runs along the eastern, not the northern property line.
Seagull Lane doesn't continue to go forward in an east-west direction?
Yes, sir.
All right? So it does go in an east-west direction. So if the smallest lot line is what's used to define, then is that in fact the the southernmost lot line, the front of Lot E?
That is the shortest lot line, yes.
That wasn't my question, sir. Is it not the shortest lot line, and isn't your definition that the shortest lot line is the front of the lot? Yes or no?
Yes, that meets the definition.
All right. If that meets the definition, then let's look at both the east and west property lines of Lot E. Can you tell me what the east property line is of Lot E, a ballparking? Let's just ask it this way. Is it more than 200 feet?
Yes, sir.
The westernmost property line of Lot E, is it more than 200 feet?
Yes, sir.
So in fact, when you made a determination that it did not meet lot depth requirements, that was wrong. You've already testified. You can say it.
Yes, sir.
All right, sir. Now, you testified that you found in your records the plat that shows certain amount of square footage, correct?
Yes, sir.
But we've already covered the fact that plats change, and that the final plat approved by the commissioners did not have that information on there, did it? You're welcome to look at tabs 3 and tabs 5, so you can look at the plats and see.
I'm sorry. What were you looking for? The
preliminary plat you testified had some language on it about the amount of square footage that was
yes.
equivalent to lots A, B, C, D, and E, correct?
Correct.
And the final approved plat does not have that language on it, does it, sir?
Correct.
All right, sir. And we've already covered that plats change through the development process, through the TRC, love that word, and through the planning board, correct?
Yes, they may.
All right, sir. Now, in your review of whether this was an approved lot, because that's the question I asked you, correct?
Yes, sir.
All right. Did you look at the minutes of the commissioners regarding the subdivision approval?
Yes, sir.
All right. Let me ask you to look at tab number 5, please. And in particular, the last page of tab 5.
Are you looking for the minutes? Those are behind 6. Tab 5 for us is a.
I'm sorry, tab 6. Yes, ma'am. Thank
Okay.
you.
Just want to make sure we're all
Yeah,
following.
I agree. Called Can't Read My Own Handwriting.
Yes, sir.
All right, now, first, the information that's contained on tab 6, I assert to you, was provided to me by Mr. Ike McCree as the minutes of the meeting of the commissioners from September 2, 1974. But you had an opportunity to review these minutes, correct?
Yes, sir.
And does this appear to be accurate and correct as to the minutes of the meeting of the Board of Commissioners from September 2, 1974?
Yes, sir.
All right. Again, turning to the last page, it has the words Seagull Subdivision, correct?
Yes, sir.
All right, and it states, on motion of Commissioner Snowden, seconded by Commissioner Vivolda, a corrected plat for Seagull Subdivision was approved. Is that accurate, sir?
Yes, sir.
All right, now, does it reference any discussion by the commissioners of anything concerning these lots other than it's approved?
No,
Anything
sir.
else there?
No, sir.
All right. Let me ask you to turn to tab number 4. And again, I assert to you that these are Board of Commissioners meetings of June 17, 1974, which Mr. McCree was kind enough to forward to me. Did you have an opportunity to review these minutes when you made your determination concerning the property?
Yes, sir.
All right. Does this appear to be an accurate representation of the Commissioners' meetings or minutes of the Commissioners' meeting of June 17, 1974?
Yes, sir.
I ask you to turn to the last page again.
Okay.
Again, it says, on motion of Commissioner Farrell, seconded by Commissioner Snowden, the final plat of Seagull Subdivision was approved. Meeting was adjourned. Correct?
Correct.
There's no indication of any discussion of any issues or problems concerning the subdivision, correct?
Correct.
You also reviewed the, as we've already addressed, the 1971 subdivision ordinance, correct?
Correct.
And within that subdivision ordinance, it provides in part, does it not, that after it goes to the planning board can submit it or makes their determination. It submits it on to the Board of Commissioners and either recommends approval or it could have recommended to the developer that the developer makes changes and the developer either does or does not make those changes, and that's noted to the commissioners, or forwarded on with disapproval, correct?
Correct.
But again, there's no discussion in any of the minutes about any problems with that development, correct?
No, none were found.
Let me turn your attention to tab number 9, if you would, for me, please.
Okay.
I assert to you that instead of putting the entire 1971 subdivision ordinance in here, I just pulled out certain pages. Does that appear to be an accurate page out of the subdivision ordinance from 1971?
Yes, sir.
All right. Just covering what we previously did, would you read the opening paragraph at the top?
If a revised final plat is not submitted, the chairman of the planning board shall transmit the final plat together with the planning board's recommendation to the county commissioners for final action. Such recommendation shall specify how the final plat is not in compliance with the ordinance and any unapproved changes from the approved preliminary plat.
And would you read the next paragraph?
The final plat and the recommendations of the planning board shall be reviewed by the county commissioners. The commissioners shall approve or disapprove the final plat within 60 days after its submission.
Just so that I'm clear, again, you were unable to find any record of any minutes of any meetings for the planning board, either for the original submittal or for the September plat.
That is correct.
All right. I think you just testified, but I want to make sure I understand that the total underlying reasoning why this was, you considered this not an approved lot, was the 200-foot width issue. Is that correct?
Yes, sir.
All right. Let's turn to something that Mr. McCreed addressed with you briefly. Would you please turn to tab 13?
Okay.
I handwrote on this, and I assert to you that I took this out of the 1992 UDO. UDO means Unified Development Ordinance. That was a joke. Have you reviewed the 1992 Unified Development Ordinance that you sent to me?
Yes, sir.
All right. Now, looking at Section 201, number 1, it says in the RO2, where the minimum lot size is 12,000 square feet, in
120,000.
1992, what?
You say 120,000 square feet?
120,000 square feet. I can't read my own writing. It's terrible, people. In 1992, do you know what zone this property was?
Yes, I believe it was RO2.
All right. Your UDO provided in part, did it not, that the following shall not be included within this definition nor be subject to the regulations described by this ordinance. A, the combination or recombination of portions of previously platted lots where the total number of lots is not increased and the resultant lots are equal to or exceed the standards of the county as shown in the regulations prescribed by this ordinance. Does that sound like what's in your ordinance?
Yes, sir.
All right. And does it sound like what was in your ordinance in 1992?
Yes, sir.
All right. Now, let's turn and look at tab number 14, please. I assert to you this is a copy of Plat Cabinet E, slide 333. You testified earlier concerning Parcel A, correct?
Correct.
All right. Does this appear to be like the plat that you saw when you were reviewing the information?
Yes, sir.
And it's true and accurate as to what It's recorded at the Register of Deeds.
Yes, sir.
All right, now, if you look at the very top, there appears to be what's called a certificate of approval dated July 24, 1995, signed by Administrator H.B. Briggs,
Yes, sir.
approving this for recordation.
Yes, sir.
Now, this subdivision plat shows that there's already a house under construction, does it not?
Yes, sir.
And so the county would have supposedly issued a building permit before this plat ever got recorded.
Optimally, yes.
Well, clearly, after this got recorded and signed off on by Mr. Briggs, the county knew that there was a house being built.
I can't speak to what was known, and
Well, Mr. Briggs
But-
knew, he signed it, correct?
well, correct, he did sign.
And he was the administrator at that point in time.
Yes, he was
All
the
right.
chief planner.
And the original square footage, without bouncing back and forth, I don't want to belabor this. The original square footage of parcel A was approximately 74,000 square feet. Does that sound about right?
Yes, sir.
All right. And now it's been reduced in square footage to around 69,000 square feet.
Yes, sir.
That's less than 120,000 square feet.
Yes, sir.
If A wasn't a valid lot at the time this plat was done, how could A now become a lot as a reconfiguration of existing lots?
I don't know if I can speak to what the administrator did at that time.
Well, it's clear at least that as a planner, you can see that this was approved and recorded.
Yes, sir.
And the county has allowed a home to be constructed on this property.
Yes, sir.
And the property is definitely less than 120,000 square feet, which was the requirement back in 1992, correct?
Yes, sir.
All right. And the only way under your then ordinance to allow Lot A to be created was if it already was an existing lot and needed access. Is that correct?
Yes.
All right. So A is an approved lot. It just needed access.
Yes.
All right. If you will, please turn to tab number 16. I assert to you that this is a copy of Plat Cabinet G, slide 94, Dare County Public Registry. In preparation of rendering your opinions that you've rendered, you in fact reviewed this plat, did you not?
Under tab 16, I've never seen that document.
I'm sorry. This young lady didn't correct me. Tab 15.
Well, I'm trying to keep up with all your plats, so I was like, okay, we have 16, yes.
Yes, sir, I recognize that plat.
You'll see sort of down in the middle, it says, this division is exempt from county subdivision regulations. H.B. Briggs Jr., dated 2000, zoning administrator. Do you see that, sir?
Yes, sir.
Same question I asked you before on parcel A. Parcel D had to be an approved property in order for it to be exempt under the subdivision ordinance to add land to it, based on your then ordinances, correct?
Yes.
All right. And there's now a house on D, correct?
Yes, sir.
In fact, the next page, still on tab 15, get it right one of these days, is a GIS I assert to you that one of my assistants downloaded because I'm too dumb to figure out how to do it.
Yes, sir.
May I approach?
You may. Thank you.
Thanks, sir.
Apparently not.
Are you familiar with the Dare County tax records? Excuse me. This is Currituck County, isn't it?
Yes, it is, sir.
Let's try that again. Are you familiar with the Currituck County tax records, sir?
Yes.
All right. The top sheet is the sheet that shows one of the subdivision plats, correct?
Yes, sir.
If you'll turn to the next sheet. This is, I purport to you, a copy of the Currituck County tax information concerning parcel E. If you come down, you'll see all sorts of things about billing, and at the one after the words billing, it says acreage. And after that, it says acreage, GIS, and then it says tax value land. You see that, sir?
Yes, sir.
And how much does it show the tax value of this property, parcel E, is?
$69,400.
If you will look at the next set of clipped papers, because they're all stapled, and again, looking at tax value, what is that number?
$69,400.
Okay. Let me ask you to flip to, there should be a whole package stapled. Go to the next stapled package. You see that, sir?
Yes, sir.
All right. Now, this one says legal description, Seagull lot number 21. Correct?
Yes, sir.
And what does it show the tax value on that one to be?
$8,250. $82,500.
All right. Go to the next set of stapled, if you would, for me, please, sir.
Okay.
And that says, for legal description, Seagull lot number 22.
Yes, sir.
And again, tax value.
$84,400.
Would you go to the next set of stapled package?
Okay.
This says legal description, Seagull lot 23.
Yes, sir.
And it says tax value $89,300, correct?
Correct.
And the last one says Lot 24 Seagull subdivision.
Correct.
Tax value land, $82,800.
Correct.
All of those being approximately about the same amount of money. There's some differences, correct?
Correct.
All right, now, the reason the plat is attached to the front is so that you can see that lots 21, 22, 23, and 24 are the lots immediately across the street to the east of parcel parcel E.
Yes, sir.
All right? So, would it be a reasonable assumption based on those valuations that the tax department of Currituck County, being a part of Currituck County, considers Lot E to be a lot?
Objection as to what the tax department might consider.
Withdraw.
I'll accept that.
That's all the questions I have at this time, sir.
Thank you.
All right, thank you.
Did, did you want to follow up before the board asks questions? Do you have any?
Whatever the
follow-up?
board's, would I like some redirect?
He might ask questions
Yeah,
that you might
that's
have,
fine.
so I would suggest he go ahead and then the board can proceed with
Yep,
questions.
that's fine.
I was referring you, Mr. Kemp, to County Exhibit E. Front page is zoning ordinance, Currituck County, 1971.
Okay.
Refer you to page 4 of that exhibit.
Okay.
And do you see the definition for lot corner?
Yes, sir.
Definition for what constitutes a corner lot in the ordinance, is that correct?
Yes, sir.
And what at that time was defined, how was a corner lot defined? Do you read that?
A lot which occupies the interior angle at the intersection of two street lines which make an angle of more than 45 degrees and less than 135 degrees with each other. The street line forming the least frontage shall be deemed the front of the lot except where the two street lines are equal, in which case the owner shall be required to specify which is the front when requesting a zoning compliance permit.
Okay. In particular, just give me just a minute, please. Okay, so a corner lot is a lot which occupies the interior angle at the intersection of two street lines. Is that correct?
Correct.
All right, so let me refer you to the plat. And we'll use Mr. Krause's exhibits.
I think you used number 3.
You can use either 3 or 5.
3 or 5, yeah, look at exhibit number 5, for the applicant's exhibit number 5. And lot E, does that lot actually extend to the intersection of Seagull and Sandpiper Road? Yeah, actually, I'm going to withdraw that question because I now see that it barely does. So I'm going to withdraw that line.
Okay.
And I don't have any further questions, Mr. Chairman.
Okay, thank you. This time, I'd like to ask if the board has any questions for Mr. Kemp.
I do, but I need a minute just to get my thoughts on something while I review this language.
Okay, so I'll go ahead and start with a couple. So, just so we're all understanding what we're talking about here, so we've got a parcel of land in a subdivision that was included in the original plat, 1974. We're talking about really the application of two different standards for a buildable lot, right? So one was what was the standard at that time, and second, what would be the standard now if you had a lot that was not buildable, but you wanted to make it buildable now? Would it have to meet the standards of today to become a buildable lot now?
Yes, sir. To record a lot, it would need to meet the current UDO standards.
Right, and can you kind of summarize for us again what was the standard in 1974 for a buildable lot and what would be the standard now?
The standard in 1974 was 20,000 square foot size, 100-foot width, and 200-foot depth. That changed where the lot size now for a lot in that zoning district is, grab my ordinance, 120,000 square feet, so significantly larger. The width is 125 feet, and there isn't a specific depth.
So is it fair to say that some of these other smaller lots that were referenced in the questioning met that standard, the 20,000 foot standard?
Not every lot in that subdivision met the 20,000 square foot standard. There is a provision in the 1971 subdivision ordinance in Article 10, and I'll read it for you just so. The Planning Commission may vary the minimum requirements set forth herein, provided that such variation will not have the effect of mollifying the intent and purpose of these regulations. So what that says is when this went through consideration, there was the ability to modify those standards.
Gotcha. Two other quick questions. So, interesting point about the corner lot measurement dimensions. That is a very odd-shaped lot there, and as you can see, it does touch, what is that, Seagull? Seagull
And
Road.
Sandpiper.
And Sandpiper, so, I guess technically it is a corner lot. As we talk about the standards for measurement of depth from the front of the lot, by my geometry, eyeballing it, it doesn't appear that you can draw a straight line from what we would call the front here to the back midpoint line of that lot without going across another property. And so my question is, would that be a proper way of measuring, to have a straight line across another piece of property to measure the depth of a lot?
That is a good question, being put on the spot. I'm not sure if I could give a definitive answer on how we would look at that. We didn't consider that when we were reviewing it.
Well,
Because if you look at it, you see that that frontage on Seagull, you'd have to go from the midpoint of that frontage line.
if you
and-
square that corner,
Right, you square that corner, you go to the midpoint of that frontage line, and you have to go to the midpoint of the back line.
Right.
to measure that depth.
But can I ask kind of on your question as well? Because this is what I've been pondering a little
Yeah.
bit as well. The two streets in question, if we were to consider it as a corner lot, we'd be considering Sandpiper and Seagull Lane as the two streets, correct?
Yes, sir.
Okay. Now, Sandpiper, the length, even if we consider the length of that, I mean, there's segments because it's not a straight line. It has curvature to it, so it has midpoints and curvature. You know, I see things like 251, 244, 109, you know, so 600 feet or so along that edge, even if we did that, right?
Yes, sir.
I mean, just doing some math. Now, if I take the other street, Seagull Lane, and I go across it, it looks like 48 or something to that effect, is what that number appears to be. Am I reading that wrong, or?
You're talking the southern line there?
I'm talking about what the frontage would be on Seagull.
Yes, sir.
But yeah, it looks like 48.
Okay, so 48 feet. So if I read 61.18, it says a lot that applies an interior angle, intersection of two streets, 45 degrees, 135. The street line forming the least frontage shall be deemed the front of the lot. And what street line would that be?
That would be Seagull.
And that would be the frontage.
Correct.
And what is the frontage requirement in the 1971 ordinance?
It does, I don't know if it had a frontage requirement. It did have a lot width requirement. The lot width is the distance between side lot lines measured at the building setback line, which, if you,
Would be the back end back here.
no, it would be, you would take the front yard
You have to
setback
take
line,
that-
you would take from the front, the southern line and pull back.
You'd have to pull that from Seagull, would you not? Because that would be the
Be the
front yard,
front, yeah.
based on the front yard definition.
Yes, sir.
Okay, so if you pulled back, you'd have to pull back to a point at which you could maintain what width?
Well, it's 100 feet.
100 feet. And then from
Yes.
that line, you would have to have how much more feet? 200 feet in depth, then from that point for your depth? Because it's measured from the building line at that point?
The depth, which case? From the midpoint of the front lot line. Yes,
Lot depth is the mean distance
the front lot line, so it would be from that front lot line to the rear,
to the
the
rear.
midpoint.
Right, but you would have to cross another property to get there on a straight line.
How do they handle curvatures on lots when they're trying to figure out the depth or the width? If it might, because right around here, this is a curve. And if
Right.
you go straight, then you're going over the street as well. So it would be the same way. I mean, the county's got to have some kind of for curvatures, although there's not that many, but you do have them from time to time.
Right, and this is a very unique lot. In this case, for the depth, you would take the midpoint of the southern, midpoint of the northern, you would draw a line in between, and the distance of that line, you know, by our definition, and then for the, right, and in the same way, lot width would be measured, let's see, the front setback is 20 feet, so you would take 20 feet from the front lot line and measure lot width.
20 feet from the front lot line and measure width?
Correct.
That's like 10 feet.
It appears narrow, yes.
So you're saying that the,
Well, you lost me there. Wait a second. What would we do?
Well, if we're talking about the criteria of all, there's the depth, but then the lot width is the distance between side lot lines measured at the building setback line. In 72, the building setback line is 20 feet from the front property line.
so if we call that, and we want to say this is a corner lot, and you were to interpret it that way and say that Seagull Lane then, because that's the narrowest side, has to be your front. If you came back 20 feet, which is the building setback line, whatever the width is at that point is what the width of the lot would be classified as.
Yes, sir.
That's a correct statement then?
Is that really a correct statement?
No.
Just,
Well, again, I'm trying to do this on the fly here.
Yeah, we all are
But-
too. I mean, so take the time you need to do with it. I want to make sure we get it right. That's what I'm trying to understand. If it's really a lot and we made a mistake, then we made a mistake. But I just want to,
Right.
I'm trying to understand this because I'm really struggling how this works.
Right, I'm just applying the lot width definition, which is the distance between side
Can you
side
read
lot
us
lines.
that definition?
Here, I think we have a slide
Why
of it.
don't we make a suggestion?
Yeah.
Remember we asked Mr. Kemp to walk us through, because we've now been asked to take a different look at this from a different angle.
Right,
And from a corner lot perspective, which I don't think was considered.
right.
And ask Mr. Kemp to walk us through his logic of how would you evaluate this, being that now, should I say, I'm sorry, sir, Mr. Gray has suggested a different interpretation. And just like to say, could you walk us through that so we can understand that? Of how we would determine what the lot width is, this being a corner lot, and obviously Seagull Lane being the front of that lot. Is that fair?
It says the distance between the side lot lines measured at the building setback line. So the building setback line has to be from the front, right? If you're measuring the width, the building setback would have to be from the front,
Correct.
right? So if you take that at face value, it's saying that the lot width is the width of the lot at that building setback point.
Correct.
Right. So yeah, go ahead. I think we asked you if you could walk through your logic. I didn't want to put any words in your mouth, but I was just reading this
The question I'm
definition.
trying to keep answering.
Yeah,
I-
yeah.
I know a lot of lots that have just the driveway going through, and then they go around, and the driveway is 150 feet, and then there's the big lot, and they build back there, and if that's true, then the setback from the beginning of the lot is the beginning of the driveway. It
Well, that
doesn't
might
make
just
sense.
be an access.
Why don't we get into that when we
Yeah.
go into debate at the end? But I
Yeah.
think let's try to answer the question.
Okay, I will walk through this based on the 72 ordinance,
Please. 71, I believe,
or
right?
71 subdivision regulations. So,
Hold on, before you do that, can we say that based on the current ordinance, that this overall lot size area does not meet the minimum?
correct, yeah, the current ordinance would require 120,000.
So we're talking.
Square feet.
The 71 now.
Because you have two choices in this matter.
Right.
You can either choose to, if the lot was maybe not recorded as a lot of record, but now, under the current ordinance, meets all the requirements,
Right. It
you
could-
could
it could,
re-record
yeah,
it
right.
as a legal lot of record, making a buildable lot.
Right, but
But-
that doesn't seem like it's
But that's,
possible based on the
that's
size
not
of this
possible,
lot.
because it doesn't meet the size.
Right,
Okay, so that's off.
right.
Now we can go back and we can look at when it was originally created, and if it meets that under one of these definitions, then it can be a legal lot.
Right.
Okay. If you were looking at this lot, you would first determine, what the,
Mr. Kemp, if you will first, when you're talking about where, since they're asking you to walk you through this analysis, if you will refer to what exhibit or plat you're looking at, I think everyone's going to follow along real close.
yes, sir. Yes, ma'am.
So if you'll just let us know what you're looking at, we can look at along with you.
we-
If
we can
look at the
continue-
Final plat.
We can continue looking at tab 5.
Perfect.
What is showing up on the screen there is a enlarged shot of that plat.
Okay.
So, first thing, you would determine what the front lot line is. So in this case, if we consider it a corner lot, and we say that lot adjacent to Seagull is the front line, from that you determine what the side and rear lot lines are. So the east and west lot lines, a curving one, and the V-shaped lot line would be the side, and then the rear would be the northern property line. Lot area is pretty self-explanatory. The lot depth, I would draw a line from the midpoint of the front property line to the midpoint of the rear, and that would be the lot depth. Even
You can cross another property to do that though, right?
Well, even at that, let's just figure out what the front is, because I'm not sure it meets
Right.
the front.
Right.
By that definition, that is how you determine depth, and that is just a, fictional line that just shows that distance. So I don't see why you couldn't cross that property line to do so.
You got area, you got depth.
And then on the width, by definition, you would go to the front setback line, which is 20 feet. So you would go 20 feet north of the front property line and measure the distance between the side lot lines.
And it gets narrower as you go back.
Correct.
Okay, and if we went at the maximum right at the street at Seagull, it looks like it's maybe 48 feet? Does that look right?
Yeah.
Yeah, it looks like 48. It looks like
Okay,
about.
and it needs to be a minimum of what?
100 feet.
So if it gets narrower, it's not going to get bigger, it's going to get smaller?
Correct.
Okay. So, looking at it from a corner perspective, in your professional review of this, does it meet the lot width requirement if we go with the suggested corner method?
It does not appear to.
So just in doing so, originally how we looked at it, it was a depth issue because you had looked at it as being Sandpiper being the front. So then it clearly didn't meet a depth issue. It was wide enough, but it wasn't deep enough.
Correct.
So now we've been asked to look at it from a corner perspective, and the corner definition directs us now to make Seagull the front of the lot. And thereby, when we apply the 20-foot setback, which is the building line, and make that measurement, it's clearly not wide enough.
Correct. It does not.
Okay. That's all the questions I have.
Mr. Craddock, you had any questions?
Yep. I have a few, I think. How you doing tonight, Mr. Kemp?
Well, thank you.
I have a couple of questions for you. In the 1971 subdivision ordinance, is there a definition of building setback line? I don't think we have the complete ordinance in front of us. It's just excerpts.
No. Yes, sir, there is.
Would you mind reading that to us?
The building setback line is a line parallel to the front property lines in front of which no structure may be built.
And you stated earlier in your comments to the board that you believed at the time in 1974, when this plat was recorded, that the building setback line was 20 feet from the front property line. Is that correct?
Yes, sir. That, I can give you, that is in section, Article 13, Section C of the subdivision ordinance. It defines the front side and rear setbacks.
What are they defined as?
From the front property line, it is 20 feet. From the side property line, it is 10 feet. From the rear property line, it is 25 feet. And from the side property line on corner lots, it's 20 feet.
Thank you.
But in determining it, you only use the front one.
When determining lot width,
But the setbacks all still apply all the way around, but
Correct.
The front width, the width of the lot, the defined width of the lot is measured from the front to the 20-foot setback.
Is that still today?
Yes, yes, ma'am.
I think even at that, it still has to apply to what was in 71, so what today is really not.
Yeah, it
relevant.
doesn't
Right.
meet the minimum square footage for now.
Yeah.
So we have to use, you can choose to do 71, or you can do today. So it doesn't meet today, so 71 is the only opportunity.
Right. Can
You
I
can't
ask a
mix and
question
match.
about the original plat from 74? So when I go back and I look at this definition, these definitions in the 71 ordinance, there is a definition of lot in there that states a parcel of land occupied or capable of being occupied by a building or group of buildings devoted to a common use together with the customary accessories and open spaces belonging to the same. So there is an inherent buildability built into that definition. It's land occupied or capable of being occupied by a building, right? So when we go to the 1974 plat, and this is kind of getting to maybe the mindset of the commissioners at the time when they approved this, if you look under the bottom right corner of the plat, Seagull, Fruitful Township,
Which tab are you on?
this is tab 5. And it states Currituck County, North Carolina, owned by Donald, can't read that, Rishan, and then it says lots 1 through 33. So, and the lots are numbered 1 through 33 on this plat. So would you say a reasonable person could deduce that the county commissioners intended to approve the 33 lots that were listed here as lots 1 through 33 under this definition in the ordinance of a lot, whereas the others were not defined as lots by this plat?
Yes, sir. When staff reviewed this, we looked at that as recording 33 lots. Yes.
But if there are amendments or different things that can be done to those other lots that weren't originally considered lots that made them buildable later, then that was maybe how we got to Lot A and some of these other things being buildable later on.
Yes, Lot A, it was a amended final plat was recorded.
Right. But nothing changed with Lot E on that amended final plat.
No, sir. We did not find any further action on Lot E.
Right.
And Lot A, when they amended it, they took away a 20-foot setback to make
They made an access, they made an access to it.
and they took 10 feet from 33 and 32?
Yes, ma'am.
So that made those guys even smaller.
It did. They still met the minimum 20,000 square foot dimensional.
But I thought 33 had some of the land added to it from that corner of A.
That happened 5 years later.
Okay, gotcha.
And that was added to
The-
D to make D buildable.
What happened is that wedge, the residual parcel from A was added in 2000. The right-of-way for A that divided it was done in 1995. In 2000, the residual parcel was added to 33. What appears to have happened, because the final plat had Lot D at 19,800 and change, what they appeared to do is have shifted that lot line, the southern lot line of D, so it picked up 132 square feet. So now made it 20,010 square feet. The planner at the time viewed that and
And that
approved.
made that a legal lot then, by doing that. And then that's what
The
they-
planner who reviewed the plan made that
Okay.
decision, yes.
So if the owner here was to buy a little triangle right there, that would make that a buildable lot? Maybe? No? depend on the size?
I probably have to speak with, the county attorney on that to see, because you would be recording, creating a new lot line and recording a new lot, whether or not it would have to meet today's standards.
Anything further?
Maybe I'm just a dense, Mr. Kemp, but I'd like to go over, you were talking about measuring the width, and you said from midway point on the front, midway, so is that a horizontal line running east to west, midway in Lot E?
For the lot width, it would be, you would take a line parallel to the southern lot line at the building setback line, so you would go north 20 feet, and that would be the lot width. The midpoint you were talking about, the midpoint from the front to the midpoint to the rear, that is the lot depth.
Okay.
And I would draw a straight line and use that distance as the lot depth.
And that would be a horizontal line running from east to west?
The lot depth would be, it would be a vertical line. The lot width would be a horizontal.
Okay.
Mr. Kemp?
Yes, sir.
Based on the testimony you have given tonight from the attorney's questions, do you believe that the letter, what was written in your letter of determination, now has changed from the reasoning for it not being buildable was the depth previously, but by how you have testified tonight, it appears that it is now width is the issue and not depth. Is that correct?
If you'll allow me just a moment to read my letter. Reading the determination letter, I don't feel it nullifies the determination letter, as the letter itself does not identify how the lot was short. The lot depth analysis was one that was, done in preparation for this. So we did look at lot depth as being the deficiency, but I don't see in the letter where it identifies a specific. It just,
Right. But based on your testimony, it appears that your initial representation to the board tonight was the reason of one of the three reasons possible was the depth and not width. But after some of the questions you've answered, it appears that that has changed now, that from which you measure the width now has changed from Sandpiper to the other street. Is that correct now?
yes, considering this a corner lot,
Previously, it was the longer side, the 600 and some odd feet side. Now it's the less than 100 feet side.
yes,
Width measurement.
correct.
Yeah, but I think in Mr. Kemp's original letter determination, it doesn't look like he
Yeah, he didn't specify a particular reason.
he said that lots A through F were not and could not have been recorded as buildable lots for one or more of the following reasons.
Right.
Letter lots did not meet the dimensional requirements of the subdivision regulations of the time, 20,000 square foot minimum, 100-foot minimum lot width at the building line, and 200-foot minimum depth. Soils were not suitable, or the lots did not have adequate access. And, I think his
My
letter,
point was mainly about
yeah,
how Mr. Kemp presented his original interpretation of why, of those three reasons. It
Yeah.
appeared that it was width-based, but now it appears that
Right.
it is more, or should I say, it was
It
depth-based
was-
originally.
yeah.
Now it is width-based, being that the streets have changed from which you measure the front measurement.
yeah.
Previously,
It's
it was on the
dimensional.
long side, now it's on
Yeah.
the short side.
Mr. Gray's asked to look at it from a different perspective, so, and
But according to the definitions, it appears that the front side is the narrowest side. Is that correct, Mr. Kemp, based on the 1971?
Yes, as Mr. Gray said,
Okay.
it appears to be so.
Is there anywhere where it's written as to why they didn't, on the 3 lot, or the 6 lots, the specific reasons why they said that they were not being recorded, that they were not approved lots? Is there anything that would, anywhere to say specifically why each one was not a lot?
No, I found no specific information for a particular lot. There was a letter from the health department that said a certain area, low-lying area of the site, didn't have soil suitable for septic. But again, it did not identify where on the site that was. That was just one of the 3 possible reasons why. But no, it was never specifically identified to a parcel as to
Right.
why it was lettered and not numbered.
Okay.
Another question.
Yeah.
Looking at this aerial photo from, on page 3.A.A, there's 2 aerial photos.
That's in the agenda packet. He's looking at the agenda packet.
I am looking at the agenda packet, yeah. Yes,
Bottom right corner, page.
page 31. It appears from this that on Lot D, a house has been built.
Yes, sir.
Okay. So now we have 2 of these original lettered lots that have been built on.
Yes, sir.
So things can change in that.
Yes,
Yeah, okay.
yes, sir.
But it doesn't seem like this lot physically is configured to change enough to change its status, based on what we've heard.
we should probably save that for debate.
Yeah. All right, any further questions for Mr. Kemp?
No, sir.
In your opinion, Mr. Kemp, based on measuring the front lot line of this particular parcel, that's on Seagull now and not Sandpiper. Isn't that correct?
Yes, sir.
Okay. And according to the 1971 subdivision rules, this would not have been a buildable lot. Now, if we know we are measuring from Seagull Street as the front lot line back 20 feet to the building setback line, that is not 100 feet or greater. Is that correct?
It does not appear to be, no.
And in today's standards, am I correct in saying that you must have 120,000 square feet for a lot, 125-foot width? And if we were to use that width at that same main building line, building setback line, is it still 20 feet in today?
Yes, sir.
So back then, it was 20 feet back from the front line from Seagull. Today, measuring, it would be 20 feet back from Seagull for the building setback line. The thing that has changed is lot width minimum requirement and total square footage of the lot minimum requirement compared to 1971. Is that correct?
The biggest change is lot area.
I have no more questions.
All right, Mr. King?
Anything?
Any more questions?
No, I'm still trying to wrap my head around something, and then it's not gonna work. I'm thinking about it. But I can, the 20 feet from the roadway, where the lot starts, and you go back that 20 feet, and that needs to be 100 feet or whatever. I can name at least, in the last 10 years, 10 or 15 houses that have been built. I know they don't do flags anymore, and maybe that's why. I don't know.
Yeah.
But I
Well,
can
we-
name
we-
at least 5
yeah.
or 6 of them along Tulsa Creek Road that have been done.
Yeah, well, we can't do anything about those.
Exactly. That's why I just want to make sure that that rule is actually correct,
Yeah.
because if it's been done, but if we're like, Sid said, 1971 versus now, I can't see that it was that much difference. It would be more stringent now than it was then.
Mm-hmm. Yep.
And yeah, you gotta build within,
Well, there's different.
from all the property boundaries, 10 feet, 20,
Well,
whatever they
it seems
are.
like either way you.
There
kinda
are
look at it,
differences
yeah.
too, though. We didn't deal with cul-de-sacs and other fire and egress methods then. Development standards have changed and become even more and more complex. So there are situations where you may have a front lot line that is narrower than 100 feet, even at 20 feet back, and it still may be a buildable lot, but it may end up being in a cul-de-sac or a different definition too. So you have to, and curved.
A lot of something like this would be in a cul-de-sac because they all
Yeah.
pie out.
But that
As they
wasn't
go
something, that's something to consider in 1971, so.
Yeah, and not
it's-
with this
And now
lot.
it doesn't meet today's because of square footage, so we can't even talk about today.
Right.
So we
But
have to
in
talk about it.
71,
But you can't mix and match.
no,
Just-
I'm staying with 71.
Yeah.
71, they should have been able to do that.
Well, and in some cases, people request variances, so when you have a unique shaped lot and unique,
Can we waive
parcels
this?
and environment around a lot where you may not be able to meet that. I can think of one, where it was kind of like a flag. It was a flag stick. They call it the flag stick lot, where it was a driveway, where it was a 100-foot driveway, and then there was a big parcel to the back. So they actually requested a variance because the parcel in the back, where they had access, would have qualified as a buildable lot, but they needed a variance based on the measurement because they couldn't meet that front setback measurement based on the width of the
And so
access.
that's what I was thinking.
So there's
from-
different things, there may
Yeah.
be different reasons why there are parcels where things like that happen, but for tonight's analysis, you're just looking at this lot and the ordinance that's before you.
Okay.
Right, and I think, remember, a lot of these standards, are not necessarily hard, fast rules, the commissioners can approve things, they can vary things, the planning department, planning board can approve things that are not, for different reasons. So there's that too.
Right.
I think so, unless we have any more questions for Mr. Kemp. I think he's going to sit there anyway, so he's not going to go anywhere. All right, thank you, Mr. Kemp.
Thank you.
County have any further
We have
showing?
nothing further, though. We'd ask for admission of the agenda package and exhibits, including
The
county
one,
exhibits
A
E and.
through
Yeah,
F.
yeah, right.
Okay.
All right. Mr. Gray, did you have any further presentation?
I would like to ask one more question of prior witness, if I might.
Yeah, I'll allow that.
All right, thank you. Would you please turn to tab 10 in what I provided? And I ask that you look at the last page of that document. And again, just to remember, this is a portion of the 1971 subdivision ordinance. Do you have that in front of you, sir?
Yes, sir.
All right. It says in item C, the minimum building setback. Okay? It says the word minimum, does it not?
Yes, sir.
All right. It doesn't say the setback is, it says a minimum. Does that not imply that setbacks can be different than 20 feet as long as the minimum is the 20 feet?
I would,
Otherwise, a pie-shaped lot, as was being discussed, would have a setback that could not be met, whereas you have a pie-shaped lot that now you can push the setbacks back far enough to meet the width requirement that you just spoke about, as well as having adequate space. Is that accurate, sir?
I would attest that the setback line is defined by that definition. When you look at the definition of a setback, it is the area of the lot that cannot be built upon. So that line denotes the edge of that area. You can build further back than the setback. So your building setback could be further than the minimum. But the setback line, I would attest, is what's listed in the ordinance.
Now, I apologize, sir. His response really didn't answer the question I was asking. May I ask it to him again in a slightly different way?
Where does it say minimum?
If you look at, again,
minimum, okay.
tab 10, the
Well-
last page under C,
And I don't want to, and maybe you can address this and rephrase your question, but, and I don't want to confuse my board, but you're talking about a building setback, and what the board was asking about was the measurement of lot depth, which is 61.19, which does not say setback. It said sidelines, front line. It does not say setback.
I understand, ma'am.
So I just want to make sure, because the board took a lot of time to make sure they understood what they were asking. And I don't want them to be confused that you're asking about a building setback, which is the buildable area within a parcel. What the board was asking about was how you measure lot width or depth, but it does not, the ordinance doesn't reference a setback line for that.
I respectfully disagree with you, ma'am.
Okay.
And again, I don't want to get into argument here. That's not, I simply want to ask a question. But Mr. McCree brought up and asked and had brought in the definition of lot width. Okay, and that's what we're now talking about. And it says the distance, this is 61.21, the distance between the side lot lines measured at the building setback line. And then we got into a statement from the witness, where the witness said the building setback line is 20 feet. And my point that I'm attempting to make is that the building setback line is not specified that it has to always be 20 feet. It is a minimum of, and therefore the line can be adjusted, and we see it in subdivisions, and I'll testify for a moment, for half a second, all the time, where we have lots of different configurations, and the setback line is designed to be sufficiently far enough in so that it meets the width requirement. I totally agree with the witness. You can't build in front of the setback line, whether it's the front, the side, the rear. I'm not disputing that issue. The issue that I'm disputing is the statement by the witness that it must be and is always 20 feet. And I'm pointing to the ordinance itself, which says the minimum. And when you use the word minimum in my world and your world, that implies that it can be something different as long as it's greater than. That's the only point I was trying to make it clear that this width issue, if you look at the lot, I'm arguing now, and I apologize for that. I shouldn't be doing that at this stage. But if you look at the lot, there's plenty of width as we get further back. Within 20 feet of the roadway? No, there's not. I agree with you. But there are significant number of lots that I'm aware of where, due to the configuration of the lot, the setback is made greater than 20 feet, or whatever the minimum is, 35 feet, 60 feet, 90 feet. One more question, and I'm going to shut up for a second. Have
sir.
you seen lots in Currituck County that have setbacks greater than 20 feet?
Well, objection, that's not relevant to this particular matter before the board in this particular parcel.
Yeah, I agree with you, Mr. McCree. I think this board can only deal with this lot in this case here. So I recognize there may be lots all over the place that don't meet the standards for a variety of different reasons, but we're not in a position to address them. Anything further?
Only I would like to make argument at the point in time that becomes appropriate with the board.
Okay, as soon as you release the witness for,
Allowed me to have an extra question, and I
Okay.
appreciate it, sir.
all right,
Thank you.
thanks, Mr. Kemp. And now it's your show.
With your permission, I'm going to stand.
Yeah,
If
absolutely.
that's acceptable. The whole purpose of this appeal is trying to make a determination that Lot E is an approved lot. That's the key concept. The response we got from the county was that it wasn't a buildable lot. And that's not the response that we believe is accurate. Let me sort of walk through a couple things that you heard. One, you heard that there's no evidence, zero evidence before you that lots A, B, C, D, and E were not approved lots at the time of creation. The only thing you heard was subdivision plat says 1 through 33, which was on the original preliminary. But the original preliminary did not delineate lots A, B, C, D, and E. If you remember that plat that they showed you, the one that thing, and the witness confirmed that it's not unusual for plats to change. We then have the adding of language of lots A, B, C, D, and E, and it got recorded and approved. There's no evidence supporting that there was any modifications that was being discussed with the commissioners. They just approved it as it was. We then have the situation to where originally you got told, well, it got denied in the letter because of the depths being wrong. And now that switched in midstream here, and suddenly it's width. And I really do want to focus on this just 1 second. As I indicated to you, and I read to you, the building setback lines. And it does say within the ordinance, as you can read, that exceptions and variances can be made, but that's not the key to this. The key to this as far as the width goes is it's from the building setback line. And the building setback line doesn't have to be only 20 feet. It's a minimum. It can be 30 feet, 60 feet, 90 feet, whatever it takes so that you have a 100-foot width. And I submit to you, that can be there. And I pointed out that some of the lots within the subdivision don't meet the 200-foot side setback, 200-foot distance requirement, but it was approved, and they're numbered lots. What you have to go on is simply the evidence that's in front of you, not speculation, not anything else. None of us were here as far as being for the boards in 1970. At least I don't think any of you were here in 1974. I know I wasn't. Ike may have been. So everything else is a pure speculation. And you can't rule on speculation. You have to rule on the evidence that's in front of you. Period. The evidence is that this lot meets all of the then ordinance requirements. There's nothing that says differently. It had the amount of square footage, it has the width, it has the depth. All of them are there. It met all of those. It has access. It meets all of the subdivision requirements from 1971. The reason I wanted to bring up parcels A and D is to show you that the county, this county, accepted parcels A and parcels D as lots. They could not have done the recombinations if they weren't approved lots. Remember what I read you and the witness confirmed? The ordinance says you can't recombine lots unless they're already approved lots. If it's not an approved lot, you can't recombine it. And if A was an approved lot and then got recombined and made itself buildable, when the access was created to it, D had some square footage added to it, but it had to have been approved lot or even adding square footage, because remember, the ordinance changed. The change occurred in 1992 to the greater square footage requirements, no longer 20,000 square feet. So when 95 and in 2000, those are after the change. Don't do that. So this county has approved those two lots as being already divided and approved as subdivision lots. And the final point, sort of, that I was making to you is that this county, I submitted to you the tax information, is showing Lot E to be a lot. It's taxing it as a lot. It's got its own separate parcel number. Now, I acknowledge you can put parcel numbers on chunks of property. They're not lots. But the valuation is not as, okay, this is not anything you can build on or anything, so it's not worth anything. It is a full value. And I gave you the values of the lots immediate across the street, a little bit closer to the ocean. But they're very comparable. To me, this county would be arbitrary and capricious by not agreeing that parcel E is in fact an approved lot, given its history with parcels A and D. And just so that I'm absolutely clear on this final point that we sort of went off on, as I've already indicated to you, the 1972 ordinance talks about minimum setbacks. You can make greater setbacks. And if you've done enough real property work like I have, and I can testify to you, there's lots of lots that have setback requirements much greater than 20 feet here in this county. I've seen them as much as 90 feet. Actually, that's not true. I know one, no, that's in Dale County. Go say something. Point simply being, we've asked this board to render an opinion to rule that, in fact, the county's letter to us was incorrect and that these lots are, in fact, an approved lot. Parcel E. Lot E is an approved lot. Now, there may be other hurdles that we may have to go through to go get building permits, but we can't even get to that point until the appropriate determination is made that this, in fact, is an approved lot and was approved in 1974. And the only evidence, to be candid, you have in front of you is the fact that it was, in fact, approved in 1974. Thank you.
Thank you, Mr. Gray. I'll ask if the board has any questions for Mr. Gray.
Nope.
I think I have one. So I appreciate what you said about building setbacks and minimum setbacks, and I want to make sure that I'm understanding the distinction here. So on the front end, we're talking about the physical characteristics of a piece of property without a building on it. And we're going to determine whether that lot is a buildable lot, right? And then you have building setbacks that govern where the structure gets located on that property when you decide to build. So my question to you is what is the building setback? If it's not the 20, what is it? Does your client have a proposed building setback that they have, or they want just a classification of the land? So absent any building plans or anything of that nature, I don't know how the county would be able to determine where the setback line is, the building setback, other than the 20 feet, to determine the width of the property.
It's very simple, sir. You take easiest way for me to stand up here. If you take that lot and you run in a north-south direction, you find the point where between east-west gives you 100 feet. That's your building setback. We can't build in front of that. By in front of it further south, we have to build behind it. And there's, I failed math so many times. So. Can I tell you exactly where that 100 feet is? No, sir, I cannot. All I can do is I can look at it, and even eyeballing it, I can tell you there is, in fact, a spot somewhere where you've got 100 foot across. That's your building setback line.
Following what you're saying, Mr. Gray, then you'd need to tell us what the lot depth would be at that point as well. And we'd still need to meet the 200 minimum feet of that, correct?
We would still have had to at that point in time, yeah.
Okay. What would the side property line setbacks be? Minimum.
As set forth within that ordinance, from the side property line, 10 feet.
Okay. And where would the access street be if I were to say this is 1, 2, 3 Main Street, which street would this house be located on, or this said building be located on? You have two choices from what I understand. One is,
Seagull.
and the other is,
That'd be Seagull if that's the
It
front.
would be single.
My expectation is the driveway would come off of, oh, terrible, I have to remember the name of the street.
It would have to be.
Sandpiper would be my guess, but am I a builder?
well, according to the ordinance, because if we're considering under a corner lot, we have to consider the front then, because the way you're measuring it, and the way you're suggesting it, then it would have to be off the shorter piece there. And I had it here in your packet. You have a lot of information, so that means it would have to be Seagull, not Sandpiper, where your access would be. Because you couldn't access from Sandpiper, but tell us that the front is Seagull. You don't really get that choice based on what it says there.
I have to respectfully disagree with you, sir. Your driveway does not have to be on the front of the property. It can be on the side of a property.
Well, it says where the two street lines are equal, in case the owner shall then specify. But if it's a smaller one, then it's a smaller one according to the corner lot.
We're mixing apples and oranges, sir. I'm sorry. Determination of the front lot line is based on the definitions right in your ordinance. There's nowhere in your ordinance that I'm aware of, and certainly if anybody can correct me if I'm wrong, that says your driveway, how you access onto your property, has to be from the front. You can come in from the side street. I can't even tell you the number of properties that I'm aware of, including house I used to own in Southern Shores. My driveway came from the side street.
Well, we're not in Southern Shores, we're in Currituck.
But my point simply being, there's nothing in the ordinance that says the driveway has to be from the front. It's not in here, sir, that I'm aware of. I mean, I can't ask questions.
Any further questions? Hearing none? All right, thank you, Mr. Gray.
Thank you.
So now the county would argue.
Yeah, Mr. McCree?
Thank you. We would submit that you just need to look at the plats, both preliminary and then the final plat that ultimately went to record in 1974. As you have noted, on the face of the plat, well, first of all, the preliminary plat is provided for a table that Mr. Kemp testified to was 33 lots, some amount of acreage that was shown as park or other type of open area, and as he testified, he calculated parcels A, B, C, D, and came up with that exact amount of acreage. So that's certainly one first indication that those particular parcels, and this particular parcel E, or Lot E, whatever you want to call it, was not intended to be a lot that was going to be built upon for this particular subdivision. Then you go to the final plat itself, and as some of the board members have noted, it speaks to lots 1 through 33. It doesn't mention lots A, B, C, D, E, F. And I would submit that if that was the intention, and the commissioners were approving lots A, B, C, D, and E, then they would have added that onto that same table indicating lots 1 through 33 were being approved. And then if you look more closely at the lots that were approved, you'll notice that lots 1 through 33 have building setback lines across all of them, utility lines down the side, but there is not the same type of delineation of building setback lines or utility easement lines for A, B, C, D, E, or F. And so that's further indicia that there was no intent that lots A, B, C, D, E, and F be a buildable lot. And we would submit that they were residual lots. that were left over from the best that the developer could do in subdividing this piece of property because of limitations that have already been denoted. They're either dimensional issues. There's evidently an issue that the health department had at the time that there were some wet areas, although granted it is not indicated exactly where. But there were some other issues or problems that we would submit cause lots A, B, C, D, E, and F to not actually be recorded as platted buildable lots. Now, I just want to briefly talk about the tax valuation issue, and I think as you all would understand, the county tax department places a value upon every tract, parcel, or lot of land in the county, including the county's properties. The county's properties all have a tax value on them, but the county is not subject to ad valorem tax, of course. And so just because there has been a tax assessment placed upon this particular lot E is not indicative or in somehow raise it to the level of becoming a buildable lot because it has a tax assessment upon it, or a tax value upon it. There's another remedy for that, and the owner can go to the County Board of Equalization Review and seek to have that tax valuation drop to a nominal amount because this lot is not a buildable lot at this point in time. So for those reasons, we submit that the zoning administrator's determination is correct, and we would ask that this board affirm that determination.
Thank you. All right. All right, so I guess we do not have a public hearing portion tonight, no speakers. So at this point, I'll close any public hearing and open up discussion for the board on this issue.
All right, well, my initial opinion is that the originally approved plat that was submitted in 74 had the intentions of not having those lettered lots built upon, or be buildable. Mr. McCree pointed out they don't have right-of-way markings on them, they don't have utility access. My only problem is that over the years, this plat has changed to make 2 of those letter lots buildable. So I would like to hear the rest of the board, what their opinions are, because I'm a little stuck right here.
Well, regardless of what happened to something else down the street or otherwise, that's not what we're determining. Whether or not somebody made an error, did it correctly, did it incorrectly, it doesn't really matter. We've been asked to say this lot currently has been told that it is not a legal lot of record for building. Now, there's language sometimes that you can confuse that with, and you can call something a lot or a legal lot of record.
Right.
And so a legal lot of record that is buildable versus just a lot.
Gotcha.
Okay? If you look on the tax pieces we got, as a couple other illustrative points, all of the other ones that were presented by Mr. Gray all have house numbers.
Good point.
The first one does not. So, yes, it has a PIN, and it is valued at a lower level, and it could have been appealed. And somebody probably should have appealed it if they couldn't build on it, because you're paying way too much money for a piece of property that you can't do anything with. Now, when I looked at it, and I'm just going to kind of go on for a little bit, if that's all right, Mr. Kane. Mm-hmm. When I went through it and looked at it, and I've dealt with these things to some degree, so I do have some experience with it. I listened to Mr. Kemp's letter, and he cited the 3 reasons why. He didn't implicitly say that, well, it's a depth issue, or it's a width issue, or it's a soil suitability issue, or it's a area issue. And you have 2 choices in this matter, as I've gone through some of this. It doesn't apply to the current standards because it doesn't meet the square footages. So there's nothing to talk about. We're done. Come to 1971 standards, and which is what applied for when this ordinance was recorded. Now, I do think that Mr. Gray brought up an interesting point about a corner lot and say, it's a corner lot. And I don't know that planning really considered it, because when I first looked at it, I wasn't sure if that was an intersection point on Sandpiper, or if it didn't. And when you get real close, because we don't have a full-size plat, but it's pretty darn good. Once you see the dot, it indicates a pin. So now we have a corner that we're turning. So, okay, yes, in fact, it is, in my opinion, a corner lot. So if I look at it from that perspective, that's why I asked a lot of those questions. And I said, okay, so if it's a corner lot, how do we determine what the front of a corner lot is? Lot corner. A lot that occupies an interior angle at an intersection of two streets, which this does, making an angle between 45 and 135 degrees. The street line forming the leased frontage shall be deemed the front of the property, except where the two street lines are equal, in which case the owner shall be required to specify which is the front when requesting a zoning compliance permit. These two are not equal, so you don't get that second choice. Basically, the shorter of the two is now your front. So if you want to look at it from a corner, which it truly is, now the front is Seagull. I can't tell you the exact number, but it's less than 50 feet. And it goes like this. So it only gets smaller. So if I go back 20 feet, and I even just scaled that, there's no way that that's 100 feet. Now, he makes an interesting point to convey as well, that that's a minimum. And I live in the world of minimums too. I'm an engineer. So minimum says that's what I got to have. If I'm building a house, building cars, minimum, minimum, minimum. Okay, so let's go back to where it's 100 feet. All right, and let's say that we could get 200. Now, I'd express that they should have presented that to us in a plat and say, here's an alternative plat. That would make this a very easy discussion for us. But right now, we got to do some geometry. But regardless of that, if I drew a line and said there's 100 feet, and I got 200 foot in depth, there we go. And it says we can measure straight back. It doesn't say you can't go over somebody else's property. I agree all those things. The problem I get into now is, if you look at it, and Mr. Gray presented it, I think it was in section 10, from the 71, it talks about minimum building setbacks from property lines. And I'd asked him this question about from the side. And the side is 10 feet. So how many sides do you have?
2.
Okay, so 2 times 10 is 20. Okay. Remember that number. So,
You're testing me, it's late.
well, yeah, I'll get to my point in a minute here, but the front has to be Seagull. So, and according to tax records and other things like that, the front of the lot is your address. According to 911 and health and safety, the front of your lot is your address so we can find your property. So you can't choose to just access off the side because I got room. You have to now access off of Seagull if you want this to be considered a corner lot. And now we have to take 20 feet away. So get onto that neck point down there at that point that just about touches, and you take 20 feet away. Now, Mr. Gray also presented to us that on Lot D, I believe it was, lots 32 and 33 had to provide a 20-foot access. Okay, now a 20-foot access, we got to do that. So 20 and 20 is what? 40. And the front of it's like 48. I'll give you 49, if you want even. You got nothing left. So you can't put a driveway in there, and you can't build your driveway into the setbacks. It has to be outside of those setbacks. So now on corner lots, sometimes there's some differences, and it's even more sometimes than 10. It doesn't say that here, but it appears that it's 10. But even using that math, I can't make the access work, even if you want to do it. I'd love to make this a legal lot for them, because I think it's a great piece of property, but I can't make it work. And that's just the simple math of it. If it was a little wider in that point, maybe, but that's the whole issue. I like all the other logic, I like everything else, but I can't make it work. If I turn to the other side and I look at it from Sandpiper, and I look at it probably from, and I'm speaking for planning and for Mr. Kemp's team, how they probably interpret was that, because at first I was kind of like, what's this thing on the side? There's no way you can get the depth.
Right.
So, it's a tough thing to chew. If the road went down on the the Swan, if there was another road, if you will, on the north edge of the page that went down through, yeah, it could probably work, but there's not. So I can't get there from here. And for me, I can't make the plat work, I can't even come close to drawing something that I could give to a surveyor to say, make me a site plan that I can show Mr. Kemp's team that this works. I like all the logic, but I just can't get there. And just because something else was wrong doesn't mean this has to be right because of that. So that's where I'm at.
Good points.
I agree with just about everything that you said, except for access to the property. Because you can access your property wherever you, if you're on a corner, you can access it from this side or this side. Your street address would be Seagull, and that which is your 911 address, and the county would have to change that. But access to the home or your driveway could be from wherever.
Not without a variance, according to what it says there. You'd have to come ask for a variance because it says this is where your front is, and you have to access from your front. That's been a total standard. I don't know if Mr. Kemp has the full piece and talks about where driveway access has or otherwise, but,
Do you happen to have that,
but regardless,
Mr. Kemp,
you'd have to have a variance for that.
for access to the property? If you're on a corner?
I'm not, well, I don't know where in the 71 ordinance that would be. I would have to read the ordinance
Yeah,
in
I mean,
full.
Is that-
It's possible, 'cause I know for a fact there's a house in my neighborhood that's like that, where it faces,
Yeah.
the house faces the same street that I live on, but they're on a corner, but their driveway is on the side from the other street.
Right,
Now, how they were able to do that, maybe a variance,
because we're looking at 1971,
right, but,
1974.
But we're not looking at this with a variance. We're looking at this in, is this a legal lot of record? This isn't a variance, can I have an access from the side or do something like that to make this work? And if that stuff, that would go to planning and they would either,
right.
you know,
That's after you determine whether it's a buildable lot or not.
this is not,
So
there's,
then we don't,
there's no
without
access.
knowing how wide this portion is right here,
It's less than 50 feet.
and I know you got to have 10 and 10, so that takes 20 out of the equation. And the
Right.
front, at best, is 49. I can't read everything with the blurred piece, but it's no more than 49. And you travel 71 feet, I mean, I can do a little geometry and get you pretty close, probably within 5 feet, but there's no way that
Yeah,
there's enough room
There's no
there.
way to get that in there through
I mean,
that.
look at the scale even on this with me here. Look at what I got
And I
highlighted.
just want to remind the board too, you are reviewing the evidence that's been presented to you, and so part of your question is at this juncture is, there's been a letter determination issued that said this is not a buildable lot. But the county has presented their case, the appellant has presented their case, and so the question before you is based on the evidence presented to you, is there evidence that you will affirm the letter of determination, or has there been sufficient evidence for you to overturn the determination? And so you're considering, is there enough evidence to overturn the determination? Did they get it wrong, or did the county get it right? So, you're not tasked with
are they able
trying
to
to
build? That's not what-
hypothesize. You're not tasked with trying to hypothesize how maybe a variance or other things could be done to make this a buildable lot. The question before you tonight is letter of determination to be affirmed? Or did the appellant present sufficient evidence for you to I just had the word and it left my brain.
Affirm.
Affirm or
To
deny.
affirm or to overturn
Overturn.
the letter of determination.
Right.
Your standards are in, the standards
Yeah.
you're to consider are in your
Yeah, we got the
packet,
standards.
about what options you have, so you can affirm the decision of the interpretation in whole or in part, you can modify the decision or interpretation in whole or in part, or reverse the decision of interpretation in whole or in part. And so the question is, based on what's before you tonight,
No.
was there sufficient evidence to affirm the decision? Was there sufficient evidence that you want to modify the interpretation? Or was there sufficient evidence for you to reverse it? So you don't have to figure out the access. We're not trying to figure out if the access, that's not before you. The question is, has there been sufficient evidence to affirm modify or reverse the letter of termination.
Right. And here's the issue that we have with that. In 1974, I was 6 years old, so we can't be back in 1974 and be in the and be in the minds of the county commissioners at that time, right? So when we look at Mr. Kemp's letter, I do think that Mr. Kemp's letter was broad enough to kind of cover all of the reasons why he felt that the commissioners did not approve lots A through F at that time in 1974 as buildable lots. And he explains the reasons why they may have chosen not to include those 6 lots with the others, right? But he wasn't there either. So he kind of lays out the different reasons. He doesn't go into specifics about the specific lot depth or width or anything of this particular lot. You know, the thing that's most compelling to me, and with that said, really the only thing that we have to go on is the actual preliminary and final plats from 1974, right? What do they say and what do they imply, right? So, you know, when you read it, it implies to me that they intended to approve only the 33, lots 1 through 33. And, you know, I have to say probably the most compelling part of the county's testimony was adding up the acreage, right, from the plat that the county commissioners approved. So that includes a breakdown of the total acreage, the total lots, which are 33, and acreage in parks and other land uses. And when he added up the acreage from those other 6 lots, it equaled the acreage in parks and other land uses that the commissioners approved. And so, you know, whatever happened since then to modify some of those lots that they met whatever standards applied to them or that the county applied to them when they modified those other lots, those are all case-by-case situations. So now we're in another case-by-case situation. And, you know, in my opinion, I think the county made the right determination here. You know, I will say that we kind of got off the rails a little bit, I think, in the testimony, and not any knock on you, Mr. Kemp, or anything like that. You know, but Mr. Gray did raise an interesting point and a compelling point about how you define the dimensions of this lot, you know, being a corner lot. And that, you know, raised an interesting question in my mind. But I don't think Mr. Kemp's letter gets into that level of specificity. And I think that it reaches the right conclusion.
It covers all that stuff.
Yeah, it covers all that stuff. And so this idea versus, you know, Sandpiper versus Siegel and all of that stuff really doesn't matter. He's making a determination based on the plat as it existed in 1974 that clearly determined that those lots were not buildable lots. And so I think the county arrived at the right conclusion. I don't know if the path to get there was necessarily completely right, but I think the conclusion was right.
I agree with you, and I think we've talked about it from every angle and situation, measurement, criteria that we could to even reconsider it. And so I would agree with you that I think they've made the right conclusion as well.
I think this could be a buildable lot. It needs to be addressed and changed, as the other ones were, as the 2 other ones were, and considered at 1974 like they were, using them as...
But based on the questions tonight,
But that's not the situation tonight.
Yeah.
There we go.
Thank you.
Yeah. Mr. Kane, any thoughts?
Good.
Mr. Craddock?
Steve, you've been very quiet,
Yeah,
and that's not like you.
I'm in 100% agreement with Mr. Miller, Mr. Breathwaite's comments. They're spot on. Mathematically, it's impossible. One of the factors that was brought up by Attorney McCree is that those lettered lots do not have any setback lines drawn on them. That's a very important point. Although in the past, at some point in 1995 and 2000, adjustments were made for lots A and D to become buildable. That's great. It doesn't have anything to do with tonight.
Yeah.
And the reality of it is not a buildable lot. It doesn't meet the standards then, and it doesn't meet the standards now.
Yeah.
Move for vote.
Yeah, absolutely.
Yeah.
Any?
Make a motion, board votes.
All right, we get a second on that? Made a
So you
motion
want to
that we.
make your motion?
He made a motion that we vote.
Raise
Yeah,
it.
you don't need a motion to vote.
Yeah.
You can go ahead and make,
Okay.
make whatever your motion is.
Unless Mr. Miller would like to.
I can do
So,
that.
so remember, we have the
Yeah.
4 standards.
Yeah.
Let's get to those.
Trying to get back to my pages, all that on, if anybody finds it before me. What page are you on?
30, yeah.
So,
All right.
Keep going to Frog Island. There we go.
All right. In the matter before the Board of Adjustment tonight, 22-03, and the question relative to the lot of record and the letter that was written by Mr. Kemp, a letter of determination, I'd like to make a motion that the standards were correctly applied and affirm the decision in the letter that was presented by Mr. Kemp in Currituck County to Mr. Edward Delaney and Tara Murphy relative to this appeal 22-03.
Can I get a second?
I'll second the motion.
All right, all in favor, say aye.
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 All opposed, say nay. All right, motion carries.
Mr. Chairman, if I might, just for housekeeping purposes, I want to make sure that we enter into evidence everything that was contained within my notebook.
Yes.
As well as the 1971 subdivision ordinance, 1971 UDO, 1992 subdivision ordinance and UDO.
And their entirety?
Pardon?
In their entirety?
In their entirety. They're not that large.
Well, hold on, let me write that down now. You also handed up the tax records, which I was gonna mark as your 18.
That's fine, ma'am.
Okay.
Thank you. And add those as well, please.
All right, do we have any announcements before we adjourn tonight? None? All right, can I get a motion to adjourn?
I would like to go home, yes. Can we adjourn?
Can I get a second? All right, all in favor, say aye.
Aye.
Motion carries.
Mr. King, can we have that book?